Colleagues, good morning. I am Antonio Benjamin, Justice at the National High Court of Brazil, STJ, and at the same time, President of the the Global Judicial Institute on the Environment. I would like to welcome all of you on behalf of the Institute. We have an extraordinary group of panelists in two different panels. The first one begins now, and at the same time, it is the formal opening of both. So we save time. And in this opening of the two-panel program on judges and the environmental rule of law, we have the president of the World Jurist Association that will arrive when he arrives, our colleague, brother, José Igreja Matos, president of the International Association of Judges and also chief Justice of the Court of Appeal of Porto and Northern Portugal. Professor Patricia Kameri-Mbote, my sister, there she is. Please, Patricia, join here for the opening. Grethel Aguilar will be speaking at the UN in 30 minutes, so she will join us later if things are not delayed there. Professor Christina Voigt from Oslo University and the president, the chair of the World Commission on Environmental Law, also a good friend and sister, and another friend and brother, Thomas Clark, here, the General Counsel of the Asian Development Bank, one of our main partners. Immediately after the opening, we have a keynote address. We invited our colleague and sister, Justice Michelle Boussaouin from the Supreme Court of Canada. And at that point, we move to panel one, in which we'll be discussing the general theory of the environmental rule of law. And in the second panel, we move into an area that is critical to the rule of law and to the work of judges, judicial education. So it's my great pleasure to invite President José Igreja Matos for his opening statement.
Thank you, Minister. It's really a pleasure and an honor to be here. I decided to do two things. First, to write a speech, because I think it's important, having in mind the importance of this forum, the importance of this topic. And the second issue was not to print it, because it's also a concern for environmental reasons. So I will, it's not too long, but it's better to organize my ideas and what the message that I want to convey to all of you. When I was elected president of EAJ in September 2021 in Rome, I set out, together with the new presidency committee, the priorities for our mandate. Naturally, our core mission is, and always will be, the independence of the courts in a framework of affirmation of rule of law. That will be one of the topics for a panel that I will share, and I will invite you all to be there in the afternoon, 2:30. I think it's panel 20 that I will moderate and share later on. However, faced with the reality that we are now living, being president of an association comprising 94 countries, undoubtedly the world's largest judges organization in the world, I thought that a renewed ambition should be shown out. This has been done. Gender issues, a recent example of which is the fruitful work in protecting Afghan women judges, and the issues of judicial integrity with the project that we also shared, that was the project Judges Against Corruption, are two examples of this comprehensive intervention. However, along this and from the first day of my mandate, an essential primacy was outlined: environmental protection. The reason is obvious. To put it bluntly, we are dealing with human survival. In this particular historical moment, maybe there is nothing more important to deal with for public officers. Therefore, it is time for us, judges, to assume also on the international stage a greater role in the defense of environmental issues. And allow me to be very clear, this is not judicial activism. Mm-hmm. This is not judicial activism. Those here in New York, but also European citizens confronted with a heat wave, tremendous, never seen in many, many years, can understood the absolute urgency of the protection of the planet. All are witnessed now in recent days because of the heat wave, but there are so many examples, the floods, all the problems with climate changes. This is not judicial activism. There is no planet B. Umberto Eco said that justifying tragedies as the mere expression of divine will often serves only to remove responsibilities for our own bad choices. Our duty as members of the judiciary is to serve our fellow citizens, is to stand firm in defense of the future of generations to come, signaling the very essence of what it means to be a judge today. Environmental law certainly exists to protect Earth, preventing and punishing harmful changes. But much more than that, its norms, strengthened by jurisprudence, today appear as ways to safeguard fundamental human rights. Therefore, it is necessary to know them and to deepen them. And this is a challenge that we judges want and actually need to undertake. Before these challenges, my presence here today assumes a double meaning. First, the manifestation of togetherness, of solidarity with leading institutions in the field of environmental law, in particular the Global Judicial Institute for the Environment, an organization by judges, for judges. My deepest respect and admiration to its president, Minister Herman Benjamin, Antonio Herman Benjamin, and his wonderful work that I've witnessed in the past 3 days, actually. And let me say, what an inspiring group of judges from all over the world we will have here today in the next 2 panels for the next 3 hours. Second to none, if I may say so. Secondly, the public affirmation of unequivocal commitment by judges worldwide to the objectives defined by the United Nations in matters of effective environmental protection. And I use the word effective this time. Goal 16, promoting peaceful and inclusive societies for a sustainable development. This is a battle that we want to deal with rationality, dialogue, democratic spirit, but make no mistake, also with the resilient conscience that time is running out. A combat in which, to quote Nelson Mandela, it is our duty to promote courage where there is fear, to promote agreement where there is conflict, and to inspire hope where there is despair. And the word despair is not a wrong word for the present moment that we live in this particular context of environment. At the present crossroads being experienced by our host planet, Mother Earth, you refuse to be silent, because silence is today complicity. We absolutely need to reinforce the implementation on a concrete ground of the legal environmental norms and instruments. This is an absolute need for the near future. Regarding the International Association of Judges, a simple message: you can always count on us. Thank you.
Well, thank you very much. The International Association of Judges is a main partner of the Global Judicial Institute on Environment, and I use this opportunity to thank its president, my dear friend and brother, José Igreja. Let me now invite Professor Patricia Kameri-Mbote, the director of the Law Division of the United Nations Environmental Program, professor at the University of Nairobi, former dean of the law school, a good friend, and as you all know, UNEP is a primary partner of the the Global Judicial Institute on the Environment, and it is in fact where our secretariat, the secretariat of the institution, resides. So, Patricia.
Thank you very much, Justice Benjamin. As the Director of the Law Division at the United Nations Environment Program, I'm happy, honored, and privileged to be here in this event. UNEP, as you know, is the leading global environmental authority that sets the global environmental agenda, promotes coherent implementation of the environmental dimension of sustainable development within the United Nations system, and serves as an authoritative advocate for the global environment. Environmental rule of law as such is our business, and we are mandated to lead the United Nations system and support national governments upon their requests in the development and implementation of the environmental rule of law, with attention at all levels to mutually supporting governance features. This entails bringing in the environment with its complexity to the rule of law space, and rule of law as against the rule of men, and also ensuring that the environment is also leveraged for peace. It also entails bringing in the vulnerable through the right to a clean, healthy, and sustainable environment for all, and ensuring access to substantive and procedural justice. We at UNEP recognize that a well-functioning legal system provides accountability and relief for both actual and pending environmental harms. Judges are very important in this role and in ensuring that the environmental rule of law is realized. And that's why we cannot be working on the environmental rule of law and not be working with judges. We are privileged, as Judge Antonio says, to serve as the Secretariat of the Global Judicial Institute for the Environment. Thank you.
Well, thank you so much, Professor Mbote. Now I invite another dear friend and sister, Professor Christina Voigt from Oslo University and the chair of the IUCN World Commission on Environmental Law, an important partner of the Global Judicial Institute on the Environment.
Thank you so much, dear Justice Antonio Herman Benjamin. Good morning, everyone. Thank you for coming here and for your interest in joining this panel and hopefully the one right afterwards on judges, and the environmental rule of law. On behalf of the IUCN World Commission on Environmental Law, it's a great honor and it's a great pleasure for me as well to provide some opening remarks. For those of you who may not be well familiar with the IUCN World Commission on Environmental Law, the World Commission is one of the 7 expert commissions of the IUCN. That's the International Union for the Conservation of Nature, the world's oldest conservation organization. And the World Commission consists currently of about 1,200 volunteer experts worldwide that work on environmental law. And our mission is to uphold and strengthen the environmental rule of law, to increase capacity and environmental legal literacy worldwide. Well, first of all, I would like to congratulate the organizers, in particular Justice Antonio and Herman Benjamin, for organizing this event and for including it in the scope of the World Law Congress 2023. I think it's an important element of the Congress, and it's very interesting to see that many environmental elements are included in the program. It becomes almost difficult to decide which one to attend because there's so much interesting going on at the same time. So thank you, Antonio, for your foresight and for your vision. Second, I second what was already been said. I think the timing could not have been better at a time when science is clear and the facts are clear that we are looking at a pluriplanetary crisis of climate change, biodiversity loss, global pollution, but at the same time political will is lacking or lagging, then attention is increasingly turned to courts, to judges, to uphold the environmental rule of law. We understand within the World Commission on Environmental Law, the environmental rule of law as the inclusion of the effective protection of the environment in our deliberations of justice, equity, rights, and duties. Courts are asked to uphold governments and private actors and also individuals increasingly to hold them to account on environmental matters. And that's most prominent these days in the area in the field of climate change, where we see a groundswell of climate change litigation in many countries in the world. And the latest development that we are observing is that this groundswell has reached the supranational level. For example, at the European Court on Human Rights in Strasbourg, where currently 9 cases are being heard, 3 are already pending, where the issue is the possible violation of particularly vulnerable individuals, either elderly people or very young people, by the impacts of climate change, in particular heat waves, on their health and their enjoyment of the rights to life and to private life. What will the court say? Well, we don't know that yet. It's still something that will happen later this year, earlier next year. But hopefully, this will be a very important decision, or decisions by the European Court on Human Rights on the positive obligations that states have to take adequate and necessary measures to address climate change and its adverse effects. It will involve the interpretation of the European Convention on Human Rights in the light of science and a contemporary interpretation taking into account the Paris Agreement and other international law. The court will probably have to establish certain benchmarks for climate action and climate justice, which will be innovative and new for the European Court on Human Rights, as well as many other courts. There are also new elements on intergenerational equity and the extraterritorial expansion or dimension of human rights that will need to be addressed. But it's not only the European Court on Human Rights. We have currently 3 pending requests for advisory opinions at international courts, at the International Tribunal on the Law of the Sea in Hamburg, on obligations of states under the United Nations Convention on the Law of the Sea. There's a pending advisory opinion request at the International Court of Justice in The Hague and at the Inter-American Court on Human Rights. The World Commission on Environmental Law is currently drafting all 3 written statements of the IUCN to these proceedings, and we are very much engaged and involved in the global discussions and discourses about international courts, or courts in general, and climate change. These are incredibly important developments that we're witnessing as we speak here, not only in the opinions by those courts, but also all those statements that states and NGOs will be submitting to those courts. And this is only on climate change. We also have many cases on biodiversity and on global pollution. Courts will be busy, and judges will be busy, and rightly so, for many years to come. It will be their duty and responsibility to uphold the environmental rule of law. And as you rightly said, this is not judicial activism. This is a duty that we all in this room share. Thank you very much. Back to you.
Well, many thanks, Professor Christina Voigt. Before I invite my dear friend and brother Thomas Clark to speak, let me just use the opportunity that I see Diego Solana, at least, oh, there he is. Diego, could you come here, please? I know you are shy. But just to pay a tribute to you. Diego Solano is a prominent lawyer in Spain, and he has been the main organizer of the Congress, of the Jurist Congress, and has managed and opened all doors for our 2 panels. You have noticed that we are the 2 panels listed first in the whole program. We are one of the very few panels with simultaneous translation. So Diego, many, many thanks. Please join me in thanking him. Well, I don't need to say that I gave him a very hard time.
No, you didn't give me at all a very hard time. No, I basically wanted to thank everybody. There are plenty of people here that I admire and I follow for a long period of time, but particularly there are 2 people. José Igreja, that I met him several years ago. He's a strong supporter and a great endorsement for the World Jurist Association and our mission of promoting peace through law. And thanks to José Igreja, we met Antonio Benjamin, and thanks to Antonio, we got you all here. We're extremely honored. One of the main themes of this World Law Congress is energy transition and climate. So having you here all is an extraordinary honor. So you're coming from all around the world, and we hope that this is not just an event, but that we join efforts to promote peace through law and to promote energy transition and climate. So thank you very much and welcome to New York.
Thank you. Thank you so much. As you notice, he is very shy. Diego, feel free to stay a little bit if you want.
I have to leave. Sorry.
Our next speaker is my brother and friend Thomas Clark, the General Counsel of the Asian Development Bank, and one of the main partners that the Global Judicial Institute has in judicial education, in everything we do. Later on, you have a chance, those that are arriving here for the first time, to meet the wonderful team of the ADB. We have colleagues speaking in the two panels, but for the moment, Tom, many thanks. Please.
Thank you so very much, Justice Benjamin. And let me say good morning, ladies and gentlemen, and esteemed justices. It is indeed an honor and a distinct privilege for me to be here. As Justice Benjamin introduced, I'm Tom Clark, General Counsel of the Asian Development Bank. I'm here with a team that I'm so proud to be a part of, including Christina and Brioni and Abi, whom you've met. They really are the shining stars of ADB, and I just try to do what they tell me to. But in any event, it is really a privilege and honor to be here. The World Jurist Association, as we heard so eloquently this morning, and I believe as we even see every 10 seconds or so up on the screen, is embracing the concept of peace through law. And that is a theme that resonates very strongly with our 21st century needs for the law. But, what is peace? Peace is not just the absence of actual war. If we look around us, we see that pollution, climate change, biodiversity loss, deforestation, these are actually, and certainly feel as though humanity is carelessly hostile to Earth, almost as if it's an act of war against the Earth. And these impacts are basically constituting the environmental crises that are shaping up to be one of society's biggest security threats. And these challenges, of course, go to all of us, and they most certainly go to our core mission at ADB. As a multilateral development bank for over 50 years, we have been committed to sustainable economic development and eliminating poverty in Asia and the Pacific. Our core business supports sustainable development by creating economic and development impact within our developing member countries. Now, that's all fine and good and very necessary. But over the last few decades, we have become aware, indeed now it is entirely obvious, that there can be no development, there can be no economic sustainable development without tackling the existential climate crises that we have. There can be no wealth, there can be no poverty elimination, certainly no prosperity, and no inclusion if we do not tackle this environmental crisis. Indeed, we're seeing backsliding, very serious backsliding against the progress that has been made during the last few decades. And the fact is that climate change, biodiversity decline, and pollution threaten the very peace and prosperity. And that is why ADB has actually chosen to become the Asian Pacific's climate bank and to invest in nature and environmental sustainability. Perhaps some of you know that this has manifested itself in our announcement of an enhanced $100 billion climate finance ambition announced around the sidelines of COP26 in Glasgow. And following on that, we have announced at the G20 last year our new energy transition mechanism, a new innovative way to actually accelerate the retirement of coal-fired and other high GHG emitting power sources, and most recently our innovative fund for financing climate in the Asia Pacific, again a way that we can use our balance sheet effectively as the G20 is increasingly asking multilateral development banks to do, to put more financing into the projects that will help address the climate challenge. Now, in the context of all of this, you may ask, what is the role for the judiciary? And this, I think, is critical. And of course, it follows on the very moving remarks we heard from retired U.S. Supreme Court Justice Kennedy and the other speakers at our session this morning. Judges are the guardians, the last bastion, some might say the last desperate hope of human, civil, political, economic, and environmental rights. The judicial branch of government is unique in its capacity to function as a referee that sustains those rights, including inclusive and sustainable development. Indeed, the courts are the institution that protects the rights and upholds the rule of environmental law. And so, if we look at that and we say, what is it judges have to confront themselves with now? It's not the same old traditional challenges. Adjudicating today requires a new breed of climate, biodiversity, and deforestation cases that create unprecedented challenges for judges. Judges now must understand technical and quickly evolving science and grapple with complicated issues like the rights of emerging stakeholders, environment and ecosystem, the rights of future generations, and whose rights are actually being compromised now, not just the people that get to go into court and litigate, but future generations, even other members of the human species and other species that we share this planet with. Against all of this, ADB has decided that we need to be doing more to support judiciaries. And that's why for over a decade, we have been deeply committed to judicial capacity building in our developing member countries, including through our flagship technical assistance agreement on strengthening judicial capacity towards sustainable economic development in the Asia Pacific, which I'm happy to say includes support for a lot of the work that we're partnering on together, Justice Benjamin. And indeed, one of the things we're looking at is not just helping individual judiciaries in particular countries, but creating a pan-regional, pan-Asia, and I dare say now more global community among judges, because we all know that it is easier to learn and strengthen yourself through sharing best practices than trying to do it all alone. So in conclusion, let me say that to make clear progress on tackling the Earth's triple planetary crisis, we need these whole-of-economy shifts. We need to be change agents of transformative change, and that has to include the law. I'm just so honored to be here today with my team, sharing the stage with the judges who embody all of these traits that we'll need. Their cutting-edge judicial solutions are the good news in this story, which is too often filled with bad news. And I want to share that ADB remains fully committed to working with the Global Judicial Institute and the Environment, the UN Environmental Program, and other development partners to support judiciaries across the Asia and Pacific as they face into the 21st century's existential problems. Thank you all very much.
Well, let me say just a few words about our keynote speaker. She is a highly respected Justice of the Supreme Court of Canada, and someone that I have heard so much about her work, her commitment to the environment in general, but especially to indigenous people. She is the only member of an indigenous nation within the Supreme Court of Canada. And when I met her, the main point of our discussion was that we cannot have the environmental rule of law without something I said yesterday or the day before yesterday. It's not with the inclusion of the views of indigenous peoples, but having indigenous peoples at the forefront of what we do. So I don't need to know that the conversation went very, very well, because we are all on the same page, and not just me, but the members of the board of the Global Judicial Institute and Environment. So, Michelle, this is your new house.
Thank you.
And I do hope that this collaboration continues, and we are sure that we will learn a lot of what we need from you, from your experience, from your wisdom, and that's exactly what we will be having today. Just a little bit of the wisdom of Justice Michelle Obosawin, please.
Thank you. Kwai ni dombak na deliwizi miseliso bansawin na zawi odanak wabanake kalnoba plawinonia. So I start off by introducing myself in my Abenaki language. As you've heard, my name is Michelle Obansawin. I'm a justice in the Supreme Court of Canada. I am a proud Abenaki member of Odanak First Nation and a Turtle Clan member. So I want to start off by thanking my dear friend for the invitation of being here today with you, and to the organizing committee. I'm quite fortunate to be in front of you at this time. I'm going to be not very long, just short of 10 minutes, and my goal is to talk to you with regard to the duty to consult Indigenous peoples in Canada when it comes to regards to environmental law issues for the different environmental treaty and First Nations rights in Canada. We have 3 original peoples in Canada: First Nations, such as myself, Inuit, and the Métis people. There are more than 630 First Nation communities in Canada, and amongst that, 50 groups and 50 different Indigenous languages. The Constitution in Canada recognizes and affirms the existing Aboriginal and treaty rights of Indigenous peoples. The duty to consult Indigenous groups has been developed by Canadian courts as a way to protect these rights. The duty to protect Aboriginal rights, Aboriginal title, and treaty rights against unilateral Crown action is essential. It is triggered where the government contemplates conduct that might adversely affect potential or establish Aboriginal rights and interests. The government conduct is often environmental in nature and can include regulatory project approvals, licensing and authorization for permits, operational decisions, policy development, and negotiations. In the recent years, the Supreme Court of Canada has heard a variety of cases relating to the development of pipelines, oil and gas, and the development of a ski resort on traditional Aboriginal grounds. In turn, cases involving the duty to consult impact the rights of Indigenous groups to conservation, harvesting, and land use and ownership. The duty to consult is meant to serve as part of a process of fair dealing and reconciliation, both of which flow from the Crown's overarching duty of honorable dealings with Indigenous peoples. The duty of honorable dealing is otherwise known as the honor of the Crown. It is a fundamental principle of Aboriginal law, and it is always at stake in Crown dealings with our various groups. The Crown must act honorably at all times with Indigenous peoples. The honor of the Crown derives from the Crown's assertion of sovereignty in the face of prior Indigenous occupation in Canada. As the Supreme Court of Canada noted in Manitoba Métis Federation versus Canada, and I quote, "Aboriginal peoples were here first, and they were never conquered. They became subject to a legal system that they did not share." This gives rise to a special relationship between Canada and the Indigenous peoples. The ultimate purpose of the principle is reconciliation of pre-existing Indigenous societies with the assertion of sovereignty by the Crown. Our Supreme Court has likened the honor of the Crown to a treaty obligation that must be respected by the Crown. So you may ask yourself, what is the honor of the Crown and what does it require? Determining what constitutes honorable dealings and what specific obligations are imposed by the honor of the Crown depends largely on the circumstances. In the context of Aboriginal rights and title, the honor of the Crown requires that the rights be determined, recognized, and respected. The Crown must participate in the process of negotiation, during which it may require to consult and accommodate the various Aboriginal interests. The duty to consult derives from the need to protect Aboriginal interests while environmental land and resource claims are ongoing, or when the proposed action may actually impinge on an Aboriginal right. The duty provides the opportunity to recognize and protect asserted Aboriginal interests from unilateral Crown action before they are even proven to exist. As noted by our Supreme Court in Haida Nation versus British Columbia, allowing the Crown to unilaterally exploit a resource during the process of proving and resolving an Aboriginal claim to the resource may deprive the Aboriginal claimants of some or all of the benefits of those resources. In that case, the province of British Columbia was contemplating action that would have had a significant impact on Haida's claim and right to title over their land, the harvest of the red cedar timber, which was at that time in limited supply. So when is the duty to consult, when is it triggered? It's triggered when the Crown has knowledge, either real or constructive, of the potential existence of an Aboriginal right or title and contemplates conduct that might adversely affect it. Now I'm going to talk to you about the test, and I'm going to break it down into two parts. The standard for triggering the duty to consult is a fairly low one. The claim of Aboriginal right or title only has to be one that is credible, and proof that claim will succeed is not required at this step in the process. What constitutes real or constructive knowledge? Real knowledge arises when a claim has been filed in court or advanced in the context of negotiations, or when a treaty might be impacted. Constructive knowledge arises when an impact on Aboriginal rights may reasonably be anticipated, or where lands are known or reasonably suspected to have been traditionally occupied by an Indigenous community. For example, in Tegu River Tlingit First Nation versus British Columbia, the band brought a petition to quash the province of British Columbia's decision to allow a corporation to build a road through a portion of the band's traditional territory. The Supreme Court found that the province of British Columbia possessed the requisite knowledge of the Aboriginal rights and title, because at that point in time, they were in the process of accepting the First Nations negotiation land claim for them to pursue those negotiations with the province, and was working towards agreement when the project was actually approved. The court also noted that it was apparent that the decision could adversely impact the band's claims to right to hunt, to fish, to gather, and engage in other traditional land use activities. The land claim covered the territory on which the road was to be built, and the claimed Aboriginal rights clearly stood to be affected by the road access through their traditional territory. What does the duty to consult require? It's simple. It requires meaningful and good faith consultation between the Crown and Indigenous peoples. It is often stated in our case law that consultation and accommodation must be meaningful to satisfy the duty to consult. The underlying objective of meaningful consultation is to foster the reconciliation by promoting an ongoing relationship. But what does it mean in practice to commit to meaningful consultation? It may require the Crown to make changes to its proposed plan based on information obtained through consultation. The responsiveness is a key requirement to consultation between the parties. In Haida Nation, it was stated that a responsive consultation process can include providing draft proposals, seeking options and opinions on those proposals, providing all of the relevant information upon which the proposals are based, and being prepared to alter the proposals if required. Meaningful consultation may also require attention to the stage at which the Crown is engaging in the negotiations with the impacted group. For example, in Haida Nation, again, it was held that meaningful consultation required engagement at the stage of granting and reviewing the tree farm licenses. These guiding examples clarify that meaningful is not just a descriptive label, but rather a standard that must be met to fulfill the duty to consult by the Crown. The emphasis on meaningful consultation is tied to the roots of this duty of honor of the Crown. In light of these roots, any meaningful attempts to meet the duty of consultation must be guided by concepts of fair dealing and reconciliation. Consultation that is not seen to be meaningful will not meet the obligations imposed on the honor of the Crown. Overall, what I want to leave with you is the notion that in Canada, there is a duty to consult Indigenous peoples when there is a potential impact on our environment, such as land, fishing, and other Aboriginal rights. And with that final comment, I wish you a wonderful event for the rest of the day. Uliuni, thank you very much. Merci.